Judgment in the appeal, Habib Khan and the General Pharmaceutical Council.
Lord Wilson will explain the decision of the court.
Many professional bodies have similar legally defined powers and procedures for disciplining their members. Their disciplinary committees generally have power to suspend a member from practice, but are often permitted to do so for no longer than a year. Usually they have power to conduct a review at the end of the period of suspension in order to decide whether to extend it. This case is about the proper ambit of a review. Mr. Khan is a pharmacist who lives in Scotland. Between 2010 and 2012, when his marriage was breaking down, he committed serious acts of domestic violence towards his wife and around the home, for which, following pleas of guilty, he was convicted of criminal offences and received a significant fine and a substantial community penalty. A disciplinary committee of the General Pharmaceutical Council found that, as Mr. Khan himself conceded, his misconduct impaired his fitness to practice. It decided that exercise of its power to suspend him from practice, which was limited to a year, would be insufficient to mark the gravity of his conduct, and that, although it might appear harsh, his total removal from the Register of Pharmacists was the only sanction which would maintain public confidence in the profession. Its direction for his removal from the register meant that he would be unable to apply for restoration to it for 5 years. Mr. Khan appealed to the inner house of the Court of Session. The court noted that were he to have been suspended from practice, say for a year, a committee could conduct a later review of the suspension and could extend it. The court held that, were the review committee to consider that his misconduct had required suspension for longer than a year, it could extend it for that reason. And furthermore, that when initially suspending him for a year, the original committee could invite the review committee to consider extending it for that reason. So, the inner house quashed the direction for removal and directed the committee to redetermine the sanction in the light of its conclusion. The council now appeals against the order of the inner house. It submits that the power of a review committee to extend the period of suspension can't be used in order to reflect a conclusion that the period originally directed was insufficient to mark the gravity of the misconduct. Today we allow the council's appeal. The function of a review is to monitor the steps which, since the date of the original direction for suspension, the member has or has not taken towards securing professional rehabilitation. At the review, the question is whether, in the light of events which have occurred since then and of the circumstances which currently exist, his fitness to practice remains impaired. Roles would be confused if part of the function of a review committee was to revisit the adequacy of the sanction imposed by the original committee in the light of the circumstances which had then existed. Indeed, in 1990, in Taylor against the General Medical Council, the Privy Council held that it had been wrong for a review committee to revisit that issue. But we also allow Mr. Khan's cross-appeal. He argues that even if the only choice open to the committee was between his suspension for a year, without any power to invite a subsequent extension, and his removal from the register, the committee was wrong to choose removal. Courts are reluctant to interfere with difficult decisions of this sort by specialist committees, but by the time of the hearing, a number of factors worked in Mr. Khan's favour. They lead us to conclude that, as the committee itself in effect acknowledged, removal was harsh. Indeed, it was too harsh. He should have been suspended for a year. But because he has been unable to practice for 3 years pending the conclusion of these appeals, we direct that he be suspended for 4 months and that a review be then conducted in order to determine whether he is now fit to resume practice.